Ladies and gentlemen, this is Thomas Dakantabi Kumavo, professional translator and translation scholar, author of the book titled De la sémantique à la traduction. In this video, we are going to discuss legal translation, more precisely, judicial writing in English and French. Correct me if I am wrong. You know, I am not a lawyer. I am just a translator, and I'm trying my best to discuss legal translation, to help translators, to help student translator to be successful in legal translation. That said, when we discuss legal translation, the first thing we have to bear in mind is that we are dealing with two legal systems, the common law system and the civil law system. When we look at the historical foundation of this system, we realize that the common law system developed through judicial decision dating back to medieval England. And this type of law is rooted in case law or judicial precedent, which serve as sources of law for the English law. Whereas the civil law system is rooted in Roman law, later codified in the Code Civil or the Code Napoleon. So this law, the French law, is based on legislation, regulation, codes, and statutes. That is what we can say about the historical foundation of this two law system, which is a very important point to know when we discuss legal translation. Now, we are going to look at the fundamental differences in legal reasoning, because if we are discussing judicial writing, we are looking at the fundamental differences in legal reasoning. This is very, very critical when it comes to addressing legal translation. What we have to know or point out here is that as far as common law is concerned, judicial writing is discursive, explanatory, argumentative, and it is based on precedent or case law. That's why you will see that when you are dealing with common law cases, reference is always made to past cases. That is, we are going to cite recent cases or similar cases will be cited in court. So we are saying that the common law judicial writing is discursive, argumentative, redundant. It is based on precedent or case law. It is fact-centered, and every step of reasoning is justified. That's why common law cases are are long, because they are explanatory, they are argumentative, and every single step in legal reasoning in common law is justified. That's why we are going to find them a little bit longer, much longer than French cases. That said, the typical structure of common law cases involve facts, we have issues, we have reasoning, we have comparison with precedent, and finally conclusion. That is what we can say about the legal reasoning in common law. What about civil law? In civil law, the judicial writing is pretty much concise. It builds on syllogism, and as we know, syllogism entail three principles, namely the major principle, which is the major assumption or proposition, and the minor proposition, which is related to the major proposition, and both proposition, that is the major proposition and the minor proposition or statement, result in the conclusion. So the civil law system is syllogistic, it is concise, it is highly focused on applying the code, that is abiding by regulation, statutes, or codes. Here, the precedent is taken into account, can be taken into account, but it is not binding. The precedent is not binding, as is the case with common law. And crucially, the typical structure of civil law cases involve, as I put it, we have the major premise, we have the minor premise, and finally the conclusion. Now, the question we can ask here is why this matters to translators, why this legal reasoning matter to translator. We have to know that when we talk about judicial translation, this is not word-for-word translation. We are dealing with culture. So judicial translation involves judicial culture, that is comparing two judicial culture such that the translation is not word for word. And that is why we are going to see that there does exist what we call legal phraseology, which is specific to judicial translation. It's true that legal language builds on ordinary language, but there are specific phrases which pertain to legal language. That's what we call legal phraseology. And this legal phraseology should be mastered in order to sound legal, so that our translation really sound legal. We can have some example when we talk about legal phraseology in terms of judicial writing. In English, when we say, for instance, on the fact of the case, this will not be literal translation. We are not going to apply literal translation here. On the fact of the case means, instead of saying sur le fait de l'affaire, this means en l'espèce or au vu des faits. This is typically legal phraseology. Another example will include the claim fails. The claim fails in ordinary language may mean la revendication a échoué. But in legal translation, the claim fails means la demande est rejetée. If we are in court, we can have some other example precisely with conjunctions like whereas in judgment, and therefore we are going to see that whereas, which is used to highlight concessive concessive clauses in legal translation is rather used as a conjunction to say attendu que. So whereas will not be tandis que, but in legal phraseology, whereas will be attendu que. The same applies for therefore, which will not be, we will not be par conséquent in a judgment, but is going to be par ses motifs. Okay. Crucially, we have to know that common law judicial writing is, as I said it at the beginning of this video, common law judicial writing is discursive and argumentative. Whereas in civil law, we are focusing on civil law is syllogistic. This is very important here because we are going to see that when we translate judicial text, this translation does not entail is not a linguistic translation to some extent. It is not a mere linguistic reproduction. It is rather a legal transplantation because we are dealing with two systems of law. That's why in one of our video we talked about comparative law, which is essential in order to achieve high quality translation in legal translation. So we are saying that when we are dealing with judicial decisions, this is not linguistic translation. To some extent, we have to take into account that on the one hand, we have the common law system, which is argumentative, explanatory, and redundant. And on the other hand, we have the civil law system, which is syllogistic. That's why you are going to see that when we quote the precedent in the common law system, when we translate this in the civil law system, we do not necessarily need to allude to that precedent. What we can talk about here is the implicatures, that is what is implied in the judicial, what is implied in the case law mentioned in the common law system. That precisely what is involved, what is intended when when precedent is evoked in the common law system. That is, if we take this example, if we say, following the principle established in Brown versus Smith, the defendant's failure to warn the victim constitutes negligence. Following the principle established in Brown versus Smith, the defendant's failure to warn the victim constitutes negligence. In this statement, we have the judicial. This is the judicial decision, and we have precedent, which is Brown versus Smith. When we translate this into French, we have this, and when we translate it into French, by taking into account the fact that the civil law system is syllogistic, we are not going to cite the case law here. We are not going to cite the precedent here. We are going to use the syllogistic version. We are going to use the meaning implied in this precedent. So we are going to say, selon le principe de responsabilité délictuelle, il ressort des faits que le défendeur n'a pas informé la victime. So what we are trying to say here is that when we translate law, we are dealing with two systems. this is not merely a linguistic reproduction. We are dealing with legal logic. And when we talk about legal logic, we need to think about it in terms of the fact that the common law is discursive, argumentative, leans on judicial precedent, whereas civil law is rooted in syllogistic reasoning. That is, the judicial precedent which is mentioned, which is binding in common law, is actually interpreted as a is just a syllogistic. We look at it from the we look at it as a syllogism. That's why in this example we said, when we say following the principle established in Brown versus Smith, the defendant's failure to warn the victim constitute negligence. And we translate it by saying, selon le principe de responsabilité délictuelle, il ressort des faits que le défendeur n'a pas informé la victime. So, the judicial precedence in the common law system here is Brown versus Smith. And what is mentioned here is what we call responsabilité délictuelle. And this is what has been deducted from the this is what have been inferred in civil law. That's why we translate it without quoting Smith and Brown, but alluding to that responsabilité délictuelle. So what we can say in a nutshell is that translating judicial decision is not a purely linguistic activity. It also entails a logic, a legal logic, which has to be transferred. That is why it is necessary to do what we call comparative, to do comparative law, because these are two systems which use two different way of reasoning. This is the end of this video. As I put it, as I said, I am not a lawyer. Correct me if I'm wrong, and if you have any suggestion, I will really appreciate it. Thank you for watching.